This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
We're now turning to this topic of how do you go about conducting cross-examination as a lawyer. And of course, this is a big topic. There are many books on the subject. People spend their life studying the subject of cross-examination. It's kind of seen as an art form, I think, and it's you never stop learning about the art of cross-examination. I've been trying cases for over 30 years, and every time I do a cross-examination, I learn something new. So it's a really complex subject. There are several goals to cross-examination, and they generally fall into these categories. You may want to elicit helpful information from a witness. There could be a witness who has been called by the other side, but has helpful information to your case. It's very common. Witnesses are often a mixed bag. They have some good, they have some bad. And when the other side calls a witness, the prosecutor in a criminal case, they may only bring out the elements that are positive to the prosecution's case and leave out the elements that are negative to their case and helpful to the defense. So the defense lawyer, in the first instance, may need to bring out helpful evidence from a witness, even though he's been called by the prosecution. Number two is to contain the negative information. You want to narrow the negative information. So you want to get positive information and you want to narrow the negative. If there's been negative information, you might find a way to make it seem less significant by your questioning. And the last point is, aside from positive evidence, narrowing of the negative evidence, is straight impeachment, where you want to challenge the credibility of the witness. As a defense lawyer, often you're challenging credibility, but sometimes there's no need. Sometimes you simply try to use the witness positively for your side or contain the negative information they had. But those are the basic goals. In terms of how you go about preparing your cross, the first statement about carefully studying the facts is the most important statement of all. It's all about preparation, all about hard work. There is no way to cross-examine a witness unless you have just studied over every single piece of evidence, every piece of information that you have available to you. So you pore over what you have, and then you decide which ways can you use the witness, which ways can you narrow the witness, and which ways can you impeach the witness. You also have to ask the question, do we need to impeach the witness? It may be that you can live with the witness's testimony and you don't find it that harmful. And you probably, there are many instances where you think, that testimony is probably true and I have no real ability to impeach that testimony because the witness is telling the truth as to those facts. And if you can live with them, if you can incorporate those facts in your theory of the case, you have no need to impeach a witness. So I think it's an important point to emphasize that not all witnesses need to be impeached. Not by a long shot. Many witnesses in a trial as a defense lawyer, I do not impeach, meaning I accept them as truthful witnesses and I try to use them affirmatively and I try to narrow their damage, but I don't cross-examine them with the goal of making them out to be a liar. Now, there are some witnesses who are so central to the government's theory of the case and whose testimony is so damaging that you must impeach them or you cannot win the case. There are witnesses whose testimony, if believed, is enough to convict your client of the crime. And as to those witnesses, obviously you need to have a plan of attack for impeachment, but it's not always the case. And if you're going to impeach a witness, you better have some good ammunition or good tactics ready, because impeaching a witness and failing is not helpful to your case. But even beyond the question of credibility, as you can see here, there are a lot of ways to impeach a witness without suggesting that they're lying. You might want to show that they didn't have a good opportunity to observe what they are testifying to. So for example, simple case, a bank robbery, and there's a customer in the bank who testifies, I was there and I saw the defendant come into the bank and take out a gun and rob the bank. You have a basic question there of the ability of the witness to identify accurately the defendant. And it could well be that the witness is not a liar. The witness is well-meaning, thinks that he or she is telling the truth, but didn't have a good ability to really observe the defendant. And maybe it all happened in a matter of seconds. Maybe the witness was on the other side of the bank. Maybe the witness didn't have a clear view of the bank robber. There were things in between the witness and the bank robber. So all of those types of factors have nothing to do with credibility, but they have to do with reliability of the witness's testimony. And there are many times when what you want to focus on as a cross-examiner is the question of reliability of what they're saying. They may be recounting a conversation from years ago that was not all that important. And you might want to challenge that, not so much as you're lying about this, but isn't it fact that happened 6 years ago? It wasn't a conversation of great moment in your life, suggesting that maybe their memory of it is faulty. And the last piece on the slide is the clear perception, and that's of the event. So these are all fertile areas for cross-examination that you have to consider in planning your cross-examination.
Leading questions, another way to describe a leading question is really that the lawyer is making a statement and asking the witness to agree or disagree with the statement. Usually, the style for a defense lawyer in asking a leading question on cross-examination is to make a statement that you want the witness to agree to. One common format, as the slide indicates, is to say, isn't that correct at the end of the sentence? So you left the house at 11 o'clock. Isn't that correct? Or isn't it correct that you left the house at 11 o'clock? I will say that some very experienced and famous trial lawyers will take the position that you don't even need that phrase at the beginning or end, that you simply just state it, and the witness is expected to agree with you. And so as a matter of strategy, the defense lawyer is the one who's controlling the narrative, not in a deceptive way, but in a way that establishes credibility with the fact finder, the jury, to say, we all know what happened here. So you could simply say, you left the house at 11 o'clock. In the end, and the witness will say yes. And so it is true that you don't want whatever formulation you use. And I think some of the, isn't it true or isn't that right, sometimes can feel cumbersome and can make the questioning somewhat awkward over time. And so certainly whatever style the questioner uses, you shouldn't use it repetitively. You should vary your style. And it may be another reason why you don't want to use those devices at all, and simply make the statement and tell the story and expect the witness to agree. often witnesses are not cooperative on cross-examination. So witnesses may interrupt the question, may not answer the question, may be evasive, try to answer a different question, or answer, well, it depends, or what do you mean by this? Ask a question back. And I think it is important for the questioner, the defense counsel doing the cross-examination, to maintain control and to, if you need to repeat the question and say, that wasn't the answer to the question, let me repeat it for you, and to repeat the question and make sure that the questioner maintains control and the witness doesn't draw you off track or distract you from what the central issues are. It's a fine line. You don't want to start arguing with the witness, like we just said, but simply to stay calm, repeat the question, and if necessary, to rephrase it or simply make it even simpler in format so there's less opportunity for the witness to be evasive or find a way not to answer the question. But again, a leading question suggests the answer. You're making the statement that you want the witness to agree with. And so the example here isn't a fact that you were not present at the time when the crime was committed. You say, in fact, you were a mile away sitting in your living room, correct? You were watching television, correct? You didn't observe what actually happened when XYZ took place. So that's the kind of line of questioning that you just lead them through a series of facts. You want to keep the questions as simple as possible, because if you have multiple facts in the statement or it's a complex question, it just gives the witness an opportunity to only answer a little bit of it and not the question that you really want answered. Again, if you're the party calling the witness, and sometimes on the defense we call witnesses, most often, certainly in the prosecution, you can only ask open-ended questions. And what that means is, so tell me what happened that day and what happened next. Now, you're not limited to that particular question. Certainly, at the beginning of a direct examination, a lawyer can focus the witness's attention on the events in question. So I'd like to draw your attention to the events of August 4th, 1999. That would be an example of orienting them to the time and place, and then say, on that day, did you have a conversation with such and such a person? And so then you set the stage to ask open-ended questions about what happened. That's an art form in and of itself, because, but it all relates, as does cross-examination, to preparation, because if it's your witness, your favorable witness, the assumption is that you've had an opportunity to prepare that witness and essentially rehearse their direct examination. So, all of this is a little bit theater and staging, because the question, then what happened, which presumes as if the questioner doesn't know what happened, of course, has all been practiced in advance, and the person answering it has reviewed the answers to the questions with the lawyer ahead of time.
I know in some jurisdictions outside the United States, lawyers are not permitted to talk to the witnesses before they take the stand and testify. But in the United States, lawyers and prosecutors are permitted and are pretty much expected that they would talk to the witnesses before they call them. They're not allowed to tell the witnesses what to say, obviously. They're not allowed to fabricate, but they can ask the witnesses ahead of time the questions that they plan to ask them in court. And the conversations that the lawyers or prosecutors have with their witnesses can be asked about on cross-examination to ensure that the prosecutors or the lawyers have not told the witnesses what to say.
In the last trial I had, the government star witness, the government met with him to interview him and prepare his testimony 24 times before trial. So this is the way it works. It is so important that preparation is the key to the whole endeavor. I just, before I cross-examine an important witness, I really will have spent just days preparing for it, because, as we say in the first bullet point here, you are confronting a witness who wants you to fail. And that is why cross-examination is so difficult. And of course, there are different types of witnesses, but we're assuming here if there is a key witness against you who wants the outcome to be negative for your client, that witness will do everything in his or her power to fight you. And if you're trying to prove that a witness is a liar, you can bet that witness will fight you every step of the way on anything that would suggest that conclusion. And that's part of why cross-examining is so difficult, because the witness is not cooperative if it's a destructive type cross. Again, there are other witnesses who you may not be challenging and they may be quite cooperative with you. But if it's a hostile, adverse witness, the only way to approach cross is to know the facts inside and out, hopefully as well as the witness, and to have a very clear game plan, blueprint of what you want to achieve in your cross. It's true that it's very helpful to know what the witness is going to answer, and I'd say to most of your questions, hopefully that will be the case. So let's start with that. How do you know what the witness must say? Well, to know what the witness must say, there are a few possibilities. Best case scenario, you have an actual prior statement from the witness. If the witness has given some prior testimony under oath, that's the golden weapon that you have. If a witness has previously testified under oath to something, you can pretty much count on that the witness will either say it again, or if the witness doesn't, that you can impeach the witness with the prior sworn testimony and get what you need. So that's the best case scenario. But more often than not, in federal criminal cases, you don't have any sworn prior testimony from the witness. Often you have these government interview reports, which I talked about earlier, which are not actual statements of the witness. They're notes from the government, and the rules governing their use are very complicated. But that is another weapon that you have in terms of knowing what the witness has said. You have a prior government interview note saying what the witness said at a prior time. Again, that's not as reliable as the witness's own statement, but it's a piece of information that you use in formulating your cross-examination. Of course, you look at every document in the case that you have available to you, and documents can be used to confirm or prove what a witness has previously said. In today's world, the best example is emails. If someone has said something in an email and you have it, that is great proof that they've said it. And if they backtrack on the witness stand, you can show them the email and prove that they said it and lock them in to that testimony. But on the slide here, we say force of logic, and I want to explain what I mean by that. And this goes to the question of, can you only ask questions that you know the answer to? And the answer in my book is no, you can ask questions that you don't know the answer to, provided one of these two last things on this slide is true, that either you have the force of logic behind you, or you have a plan for a yes and a no, and they're kind of related concepts. So let me just explain what I mean by the force of logic. Let's say that all you have from a witness is a statement, I left my house at 11 p.m. And let's say that relates to the case in some way. What happened after they left their house? Well, that may be the only piece of information that you have them locked in on, but there's an enormous amount that you can infer from logic from that one fact that you can count on. So if it were relevant to the case, you could count on the fact that you would get a yes answer if they left the house at 11 p.m. So it was dark out, correct? Yes. So the streets were not as crowded as they are during the day. Yes. So some of the stores were closed. Yes. The restaurants, many of them were closed. Yes. Now, again, this would have to be relevant to the case, but my point is there's a litany of things that you can infer from one fact that must logically be true if that fact is true. And often in cross-examination, you can use that to your advantage because the witness has no choice but to agree with your question, even though they've never previously said it. They've never been previously asked, was it dark out? But they have to say yes, because logically, it would have to have been dark out at 11 p.m. And if they say no, you can make them look silly, unless they live somewhere where it's light out at 11 p.m. But in most parts of the world, that would not be the case. So that's just an example of the way your mind has to work on cross-examination. And it's why you can take one fact that you know and infer from it a whole host of important facts that may be very helpful to your case, that you can count on the fact that the witness is going to have to adopt them because the force of logic requires them to. And in that instance, you have to be prepared if the witness does not adopt what you think is true from the force of logic. You have to be prepared to make them look silly. For example, no, it wasn't dark at 11 p.m. And let's assume we're in New York City, where it is most definitely dark out at 11 p.m. You have to be able to immediately challenge that. Well, is it your testimony that in New York City at 11 p.m. there are days when it's light out? And the witness has to say, well, no, that's not the case. So you use logic to confirm what the witness is saying. And the last point on this slide is, it's not that you don't have to know the answer to every question. It's that you have to have a plan for a yes and a no for every question. So there are many questions that you don't know the answer to, but you've figured out in your mind that whether the answer is yes or no, I can use that to my advantage. It's kind of a decision tree. If the witness's answer is yes, I'm going to go down this road, and I know I have a point that's helpful to me. And if the witness's answer is no, I'm going to go down this road, and I know I have a point that's helpful to me. So as long as you have either the force of logic or a decision tree plan that you're comfortable either way, you can ask a question that you don't know the answer to. But it's always best and safest if you've got a clear document, a clear prior statement, and you know the answer, then you're on the most comfortable terrain.
Impeachment is sort of a fancy word for making the witness look less credible in some way or another. One way to do that is by suggesting that the witness is biased somehow, that they have some ulterior motive, some hostility against the defendant that would give them a motive to lie, to make up something that wasn't true. For example, maybe they've had a long rivalry, a workplace rivalry with the defendant and wants the defendant's job when the case is over, which will pay the witness a lot more money than the current job they have. In that situation, they have a self-interest which may lead them to exaggerate or make the defendant look worse so that their own self-interest is advanced. The second category, lack of ability to observe or to know. When we talked about the Crawford case, we suggested maybe the wife didn't have the opportunity to observe what was in the victim's hand, whether there was something in the victim's hand. But this issue also comes up not just with eyewitness testimony or the ability to observe events, but with respect to knowledge, right? Many of the trials that take place in our country in federal court are white collar trials. So and those trials come down to the question of knowledge and intent. Did the defendant intend to commit fraud, or did they simply make an innocent mistake? Did they have bad faith, or did they act in good faith? And so, or did they know or have full understanding that a fraud was being committed in the workplace and participate in that fraud, or were they unwitting participants in the fraud? And so you may, on cross-examination, be questioning a witness, cross-examining a witness to establish that your client didn't have full knowledge. So for example, you may be saying, isn't it true that you never sent that memorandum to my client, Mr. Smith? Isn't it true that you never CC'd Mr. Smith on any of the emails that you sent to the boss? And isn't it true that Mr. Smith was never at any of the meetings that you had concerning the subject matter? You're using the witness helpfully in that circumstance to limit how much your client knew. But you may also be trying to impeach the witness's extent of knowledge about what they observed or what they knew was going on in the workplace. Prior inconsistent statements, I think Larry's done a fair bit of explanation about this already. You're trying to show that this person can't be trusted because they changed their story. They changed their story maybe to fit what the government wants them to say. Why would they do that? Well, maybe they have some liability too. Maybe they participated in the fraud, or they participated in the crime in some way, and the government is giving them a benefit in order to testify for the prosecution. They will face less time in jail, or they will maybe in some instances have a non-prosecution agreement where the government has promised not to prosecute them. So they maybe when they first were interviewed, they said something that was more helpful to your client. But after many 24 sessions, as Larry said, with the prosecution, they've slowly changed their story. And now the story has been tweaked and fixed so that they are now making a statement that's more consistent with the government's theory of the case than with the defense. And you really want to point that out to a fact finder to say, is this a reliable statement, the one that they're presenting in court? Or maybe the more truthful account is what they said earlier. And in any event, given that they've changed their story, they can't be relied upon. And then finally, prior acts of dishonesty. And this maybe goes to questions not only of matters that the government may have disclosed to you, because the government doesn't always know every act of dishonesty that their witness has engaged in. But I've heard of cases where, for example, the defense has managed to dig up instances of credit card fraud, or of lying to your employer about the reason you took days off, or cheating on your spouse. All acts that make the person that's testifying a less credible and reliable person, so that the jury is less likely to trust their account that they're presenting on behalf of the prosecution. So those are some examples of ways to make the witness seem less credible on the witness stand.
You've got to have clear goals. You have to have them written down in front of you so you know what you're trying to do. And don't wander in your cross-examinations. Know why you're asking the question, what your goal is, and when you reach your goal, move on to your next topic. Keep it short, make your points, don't wander. You have to ask short questions, because if there are multiple facts in a question, it gives the witness a chance to try to wiggle out of it, get out of it. So your questions must be short, crystal clear, and have one fact only in them.
As a woman criminal defense lawyer, I believe very much that it's important for every lawyer to find their own voice and their own style and to be yourself. So while on television, there's a style of criminal defense cross-examination that's suggests even with the police officer that you have to be very macho and aggressive. You can be quote unquote confrontational and aggressive and very effective without fitting into the typical style of a more macho aggressive style. So I think while certainly you have to be strategic with respect to the witness that you're dealt with, whether if it's a victim, you're going to get nowhere by being aggressive. Ultimately, as a lawyer, you're going to be effective and powerful if you are very much yourself and you're adopting a style that you're comfortable using.
Larry's prepared a demonstration based on a cross-examination he did in this case.
So this was a fascinating trial that I had several years ago that arose out of the Bernard Madoff scandal. He's fairly well known around the world as one of the biggest, largest frauds ever committed, the largest known fraud probably in history. He had an investment firm that solicited investments from its clients. It had billions of dollars that it was supposedly investing. And after some 30 years of being in business, it came out that, in fact, he wasn't investing any of the money, he was just keeping it. And the entire premise of the business for 30 years or 25 years or so had been a lie, that there were all these investments it was making. In fact, they weren't making any investments. It was what's known as a Ponzi scheme, meaning you take in new money to pay old investors, and you just keep it rolling with new money funding old investors to give them, the old investors, their profit. But what was miraculous is that he managed to keep that floating for decades. The trial, when Bernard Madoff was discovered, when it was disclosed that it was all a fraud, he pled guilty, and he got 150 years in prison as his sentence, so he's still in prison. But a couple of years later, the government charged several employees who worked for him with participating in the fraud. And the trial that I did was actually of 5 employees of different levels within the organization. My client was a computer programmer who worked on the programs that were used to carry out the fraud. And the question at the trial was a very narrow but critical one, which was, did he know that the computer work he was doing was being used to commit a fraud, or did he think that it was an honest business? If he thought it was an honest business, then he was innocent, even though his programs, in fact, we know in hindsight, were used to carry out the fraud. But if he knew, then he's guilty. And so it was a trial, as many are in the white-collar world, based on the question of his knowledge of the fraud. The government called it trial. Its star witness was Madoff's chief assistant, whose name was Frank D. Piscali. He had been with Madoff for 30 years, and he knew the scheme inside and out. He was the principal architect of the scheme. So he was pretty much as guilty as Madoff was, but he cut a deal with the government where he became a cooperating witness, trying to reduce his sentence, and he testified at trial on behalf of the government. He was a fascinating witness to cross-examine because he had a lot of bad information about my client. He also had a lot of good information about my client. He was a mixed bag, and he had a lifetime of acts of dishonesty, which he admitted. So there was a lot of ammunition for cross-examination in terms of him having spent 30 years lying to people in connection with this fraud. So when I approached my cross-examination of him, and the 2 excerpts I'm going to show, we reenacted it here in my home yesterday, which is why it looks as it does. But it is from the actual transcript of the trial. And I'll just say I had 2 separate goals. There are two demonstrations. In the first demonstration, I was trying to use the witness affirmatively, meaning the witness this Frank DiPasquale admitted that for many years he lied to my client about why these things needed to be done, why these various computer programming tasks needed to be done. He gave him cover stories to make it sound innocent. This was very helpful to me, and so I wanted to elicit it, and that's what I do in that demonstration. And I knew that he had to acknowledge it because he had acknowledged some of the lies in his interview notes. So I was confident that he would have no choice but to acknowledge them to me. But the second part of the demonstration is a challenge to his credibility. And the reason that I had to challenge his credibility is, although he had helpful testimony, he also had damaging testimony, because he testified that my client had worked there for 20 years. And he testified that although he lied to them for like 18 of those years, in the last 2 years, he started to tell him more of the truth. And so that was very damaging to my client. And so I had to walk this line between using him affirmatively to bring out the lies, but then suggest that he himself as a witness was fabricating what had happened in the last 2 years. So it was a complex cross-examination. And you'll see the two parts. The first part is using him affirmatively, and the second part is trying to attack his credibility based on his life of having lied and committed frauds and having previously committed perjury before the SEC. One thing I just need to add, so that context to the slide, to the demo rather, is earlier in the case, in the facts of the case, there had been a Securities and Exchange Commission audit of Madoff Securities, and this witness, DiPasquale, had committed perjury at that hearing, and so I was able to cross-examine him on that. And also as to that SEC audit, and this is just critical to understand the first of the two demos, Madoff was audited by the SEC and gave them 20 customer files and claimed that he only had 20 customers. In fact, he had hundreds of customers with billions of dollars. So they lied to the SEC, and the programmer, my client, was asked to create records for only 20 clients rather than all the clients. And the question was, did he know that that was lying to the SEC, or did he not?